Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers in the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy. Hi, today I want to welcome Rebecca Tooman, who I have had the pleasure of working with several times now. And Rebecca, you specialize in estate planning. And I don't know are you still doing divorce law too, or not really?
I do quadros still for family law, which is a division of pensions and 401ks and retirement plans. I still have a few cases left, but I'm definitely transitioning into estate planning, which I love. Family law was wonderful too, but I'm a lifelong learner and love learning new areas of the law.
And you're so good at it. And the people that have worked with you have all said that you are so organized and so smart and that you explain things so well, and they really just feel like they're very well taken care of when they work with you.
Thank you so much. That means so much to me. Thank you.
Yeah. And I appreciate referring people to you, including myself now.
Yes.
Because you have gotten rave reviews all over the place. That's for sure. So will you explain the basics of what is estate planning and why does someone need it, or why would someone not need it yet, just in like the basic terms so everyone understands?
Sure. So let's start with a client that just went through a family law process.
Okay.
So it could be a young family, someone with minor children, for example. So they've just gone through the family law process, figured out the judgment, how to divide all their assets, and now a single mom, for example, with young children, if she did not have estate planning in place and something happened to her, it could be disability, it could be death, her children would typically inherit her assets directly, which means they're minor children, so it would all have to go through court. It means the ex-spouse would most likely be the one in charge of that mom's assets because that parent, the father, would be taking care of the financials for the children and would have to go to court to also become the conservator for the children. So most of the time, we would not want our ex to be in charge of our assets for our children. And we definitely would want to protect our children so that they don't inherit assets at the age of 18. Because once the children turn 18, then the conservator typically has to turn the assets over to the 18-year-old. Sometimes it could be 21, but part of it is also disability planning. So I always use coma as an example. If someone is in a coma, they will need someone to step in and help manage their assets, whether it's a power of attorney or a trust. So there's typically quite a few documents that are part of the estate planning package to help someone get organized with their assets to plan for disability and for death.
Right, which obviously are two very, very different things.
Exactly. So we have a power of attorney, and it's actually really exciting. In July of 24, we have a brand new law in Michigan. We joined 30 other states with more of a uniform statutory form, and there's two really great things about it. The first thing is, with a power of attorney in the past, Michigan did not have a law in place that said if the financial institution rejected the form, there was no consequence. But now we have teeth to the new law that says if, and I'm just going to use Comerica or Chase Bank as an example, if a client were to take the statutory power of attorney form into the bank and they rejected it, the law now says that the bank is responsible for attorney fees and costs that the person has to go to court to implement to get Chase or Comerica or whatever the bank is to accept the form. So yes, that's really exciting because every financial institution started having their own form, and you wouldn't know that. And once you're incapacitated, you can't go around and sign a whole bunch of forms. So it's really nice that that's in place. And then the second update to the law, which is exciting too, and I'm just going to pick on you, Carri, as an example. Say that you're my backup person, say you're my agent, and you wanted to go on a vacation. So you went ahead and took $10,000 out of my bank account to have a nice vacation. Well, if you were to take that money out and not have good faith with taking the money and spending it, you would owe back 3 times the amount. So there's more consequences if an agent were to take advantage of someone's bank account, for example.
That's great. That is and the power of attorney was a question that I had for you because I kept hearing people say that you have to go to the bank and ask for their power of attorney.
Right, exactly. So it's wonderful because with estate planning, let's just use property as an example. Say that I buy a house, but I can't attend the closing. I could sign a power of attorney form to make Carrie my power of attorney, my agent, and then you could go to the closing for me and sign all the documents as my agent. So if I'm in a hospital, need to travel, you would be my backup person. But let's say I put my house in a trust so that it's part of my estate planning. If I needed you to sell my house, I could do that as well. I would then make you my successor trustee, my backup person, and then you would have authority to manage my assets that are held in my trust. So it's a great way to help manage real estate, whether it's a power of attorney or a trust.
Right. No, that's huge. And I know there's places that I've worked in the mortgage industry that would never close a home in a trust. And they always wanted the people to take the house out of the trust, do their mortgage closing, put it back in the trust. And I'm like, my luck, something would happen on the way to the closing. And that would be the worst thing that we could tell somebody to do. Where I work now, they allow you to close in a trust, but it took me a long time to find a place that would allow that
Yeah.
employment.
Exactly. I've had that same experience where if I wanted to apply for a refinance, for example, for a great interest rate, I had to take my house out of trust to do the mortgage for some reason for the mortgage company to become the primary creditor, maybe, and then put the house back in trust. But what is also interesting is if I were to sell my house while it's in trust, well, the payment would go to my trust. So I would have to make sure I had a trust account to deposit the funds, which isn't a bad idea to have a trust account. And it's easy to open a trust account. You just have to bring a certificate of trust, which is usually a 2 to 3 page document that you have a trust, which is a notarized form that you sign. And if I were to, if I didn't want the trust to receive the money, then I would have to take it out of trust to sell my house so that it's back in my individual name. And every time you do a deed with the Register of Deeds, it's usually at least $30 for the fee to record a deed. My personal preference is to do what's called a ladybird deed, which is a fun term. So there was a professor in Florida back in the 80s, and I think he referenced this deed in a seminar, and he referred to it as a ladybird deed, and it's kind of stuck since the 80s. But a ladybird deed is just a life estate. So it says, I own my house, I can do whatever I want with it, but I gifted myself the house for my lifetime. And so during my lifetime, I can do whatever I want with my property. But if I were to pass away and own any interest in that house, then it automatically transfers either to my beneficiaries that I've listed or into my trust. And so usually it's easier to transfer into a trust because then you have one person in charge. If I had more than one child, if I had 2, 3, or more children, I would have to decide how are they going to own the home, whether it's tenants in common, right of survivorship. So that's a whole nother way to own property, different ways to own a house with someone, whether it's right of survivorship means you would inherit the house if someone else that co-owned the house passed away. But tenants in common means that share of the house would pass on to that co-owner's family. So for example, one of the cabins across the river from an area I like to vacation, I think there's 34 cousins that now own the property together.
Oh, God.
So they all own it as tenants in common.
Oh, goodness. We have issues when you have a divorce and they say, okay, you're going to own your home together still and not have to refinance right away because your interest rate's really good. And we don't, so-and-so can't afford or doesn't want to afford to refinance to a higher interest rate. So we'll just keep everything the same. And then they forget, or no one says, you go from marriage, tenancy entireties, to tenancy in common. And then of course, somebody gets remarried or there's a girlfriend or, who knows what happens in the future, right?
Right.
And you have a very tangly mess because you were trying to be the good person and not say that you had to refinance your house or someone had a judgment against them or some weird thing happened.
Right. And we've collaborated together to help couples that have been almost in that same situation. And a house trust is a perfect tool to help a family going through divorce in which there's a really great interest rate and they don't really want to refinance the house, say for maybe 5 years or until there's a better interest rate. They could own the house together as co-trustees and have very specific terms. So whoever stays in the house would have to manage the house, pay the bills. And then if something were to happen, whether it be disability or death, the house would still be in trust so that the person whose name is still on the mortgage would be able to help sell the house and pay off the mortgage without the house passing on to a new spouse or other family members. And co-owning a house, that would be um, a trip to probate and trying to figure out who all owns the house. And the house would likely be tied up in probate for probably 6 to 12 months.
Right, and that happens so often, and then you always think, oh, well, we're going to refinance in a couple months, not going to be that big of a deal. And then I was just talking to someone earlier, like a couple of years ago, everyone had that in their judgment, thinking, the government said rates are coming down, rates are coming down. Well, 2 years later, there's no interest rates that have come down. So now there's all these people that were going to do something that never did anything, and they don't even realize what a mess they're in.
Exactly. Yes, it can be quite a nightmare to co-own a house with someone for up to 30 years and have no way to resolve it. If the house is underwater, if you can't sell it, if there's issues with
Right.
trying to, yeah,
Even
so
if the mortgage is paid off, they still co-own together.
exactly. Yeah, a lot of people don't know it automatically converts to tenants in common. So it's very important to understand how that works.
Right. So I was going to ask you if you know the answer. Can you own a home with your spouse as tenants in common, or does it always be entireties?
That's a really good question. And what's really interesting is couples will say that they've resided together and bought a home and then got married. When
Ah,
yeah, so they purchased the home, and then when they purchased it, if they didn't fill out the deed any different, it would automatically be tenants in common, that they each own 50% of the home.
okay.
And then once they're married, the assumption might be that it switches to tenancy by the entirety, which means right of survivorship together. It's not. The law does not automatically convert the home. You would actually have to go in and change the deed from tenants in common and re-sign it as a married couple so that the deed says husband and wife, or a married couple, of course. And then you would own the home as tenants by the entirety. If you were to own a home, let's say maybe it was an investment property, a second property, if you didn't list it as a married couple, if you just listed it as tenants in common or right of survivorship, I believe that would override the statutory right to own it as a married couple. Um, but even if you buy it as a married couple, you still want to make sure it has the magic words that it says a married couple in order for it to be the tenancy by the entirety. And then tenancy by the entirety actually offers a different layer of creditor protection a lot of people don't know about. So
Right.
when you own the home as tenancy by the entirety, let's just say there was a single creditor for one of the spouses. Let's just say they ran up a credit card bill. That or something where somebody could attach a lien against the house. As long as they own it as a married couple and it's an individual creditor for only one spouse, that creditor cannot make a claim against the house. It's protected by the marriage.
Right. Right. And I have had instances of that where I've had divorce attorneys not want someone to refinance and redo the deed until after the divorce was final. So we had tenancy by the entirety, everybody protected. Then the judgment was final. Now tenancy in common. Now one of those creditors gets attached to the house. And of course, it's the other spouse who needs to refinance, and now they have this debt on their title. That happens too.
Yes, it
I'm
does. And
glad
that
you
was
brought
something
that up.
that yes. So I personally proactively, most of the time we were able to create a settlement agreement or a mediation agreement and included that as soon as the divorce was final, that the couple would sign a new deed to either convert it to right of survivorship or to consider a house trust before their divorce, so to make sure that they continue to own the asset together with specific terms in place.
So many sides to the piece of dice, isn't there? Like, you have to think of all these crazy things that most people wouldn't wouldn't think about it.
Exactly. And then if you decide to remarry, then usually you have a blended family situation, and then you have to decide, what if one spouse owned the home prior to the marriage? Or what if one spouse wants to leave the house to just their side of the family, so that we would create a life estate, for example. So that would be something that you could do either with a deed or with a trust. I prefer to do it with a trust. So if I was a single person and decided to remarry, one option is that I could set up a trust, and I could specifically say in the trust that I own this house. But however, now that I'm remarried, I want my spouse to have a lifetime right to stay in the house. So usually you have to put some parameters in place. Would you want, if something were to happen to me and my spouse remarried in the future, does that life estate terminate upon remarriage? Does it terminate if they have someone cohabitate with them? Because really the goal was to pass on any equity to maybe, my side of the family, if we had a blended family, for example. So
Right.
there's
And you
different.
can have someone that needed long-term care that had that person live in the home with them. Not even a
Right.
romantic person.
Exactly. Or if there's a problem where the bills aren't getting paid, then you want to have enough provisions as part of the trust that the life estate would terminate if there's waste happening, the bills aren't getting paid, the property taxes are behind, things like that. So these are all revocable trusts that we're talking about. And what's interesting about a revocable trust, it's also known as a living trust, is that once a person passes away, the trust becomes irrevocable as of the date of death. And irrevocable means the terms are in place to be followed upon that person's death. So, and a trust is really just a contract. So it would be to honor the person's wishes so that the terms are followed, to make sure that the assets are either passed on to family members or to charities or entities, however that person wanted to leave their money or
So it could be
trust asset.
changed up until that person's death if they wanted to redo things.
Exactly. And a trust is very easy to update. So for example, let's just say I wanted to change my successor trustee from my sister to Carrie. I could just sign a one-page document that says I changed my trust provision 5.3 from so-and-so to Carrie to act as my successor trustee. And you would be in place if I was incapacitated or upon death to help manage my trust assets, which could be really any kind of asset that could flow into the trust. So for example, a house could be deeded directly into a trust or flow into the trust upon death with the ladybird deed that we were just mentioning. All my real estate, which is really interesting, if I had real estate in Florida, Tennessee, Georgia, Michigan, if I had a whole bunch of real estate, I would have to probate each and every state. But by putting that property into my trust, I can have it as one trust where one person, my successor trustee, such as Carrie, would be in charge of all that real estate to be able to sign, to sell the property, manage the property, which is another huge benefit too.
Yeah, it makes it so much nicer. So tell me the players of the trust. So I know you have different players. Go
Yeah,
over
sir.
go
It's
over
interesting.
the people.
It is. There's so many terminologies for it. In Michigan, we typically call the person who creates the trust the settler, which is a fun word, or it could be a grantor, or it could be the initial trustee. It's all the same thing. So the person that creates the trust is the initial trustee in charge of their trust. So if I create a trust, I would be in charge of my trust as the initial trustee, and I would be the primary beneficiary. So it's great for disability planning because if I was in a coma, then Carrie could step in as my successor trustee, make sure my bills are paid, my hospital contracts are managed, my affairs are in order. And then upon my death, whoever I listed to distribute the assets to would be the secondary or the contingent beneficiaries. And what's great about a trust is once it passes on to my children, for example, they have creditor protection for my trust. So while my assets are held in trust on behalf of my children, a creditor such as a divorcing spouse, maybe a creditor that's owed debt or a bankruptcy or something like that. While the assets are held in my trust for my children, it becomes a creditor protection trust. So assets are protected. And then I could decide at what point I want the money to be paid out to those contingent beneficiaries. So then we have the successor trustee that we mentioned would be the person that steps in if I'm in a coma or upon my death, there's a successor trustee to help manage my my assets on behalf of my family and for me until death.
And then so you have the grantor,
That makes the trust.
you have the trustee,
which can be the same thing. Or if I'm in a coma, now if you've become my trustee,
then it's a different person.
yes. So it's
And the
considered a successor trustee.
beneficiary, and the beneficiary is only on death, right?
No, that's a really good point.
Okay.
So if I make a trust, I'm the beneficiary. So if I'm in a coma, I'm the sole beneficiary and all duties owed to me. These are my assets that need to be spent on my behalf, or maybe anyone dependent upon me. And then after my death, the secondary beneficiaries would be the ones that the assets are transferred to upon my death.
Okay. Yeah, it gets very, very confusing.
Especially when there's so many labels for all the different words. I've seen trust maker, settler, grantor, initial trustee. It's all the same thing. So that I think that's part of the confusion. But a trust is really just a contract, how to manage your assets.
Okay. And when they say avoid probate, everything really does still go through probate, right? It just goes through quicker, or do you literally just skip it?
You literally just skip it. So if
Okay.
something is part of a trust, it passes outside of probate. So the reason for probate is because, let's say I own my house, but I didn't have a plan. I didn't have a ladybird deed. I didn't have a trust. Well, no one can sign for my real estate. There's no one with legal authority to sell or transfer my real estate. So my house, my real estate would end up in probate so that the judge would transfer authority to the person in charge of my estate, known as my personal representative or executor. It's the same thing, so that they would have legal authority to sell my house, showing that they have proof from the probate court that they have authority to sell the house. But what's really interesting about probate is that, let's just say I needed Medicaid as I got older. If my asset goes through probate, then the government has the right to recapture the Medicaid uh, money. So if my house went through probate and I was on Medicaid, then the law says that the money goes to the state. But the law
Okay.
also says if I avoid probate and have a tool in place, like the ladybird deed or a trust, then my asset would pass outside of probate and my family retains the money. Each state has its own policy, but that's currently the law in Michigan.
All right. And I have heard something about Medicaid and recapture, and then and this might be out of your realm of expertise, but I heard something regarding Medicaid, and if you have an irrevocable trust, then it doesn't count as assets to qualify. But if you have a revocable trust, then it does.
That's
Everything's
right.
so confusing.
Yeah. So a revocable trust, if I have the ability to take my assets in and out of trust, then there isn't a creditor protection because a creditor could make a claim against my house, for example, even though it's in trust. But if I were to put my house into an irrevocable trust, there are Medicaid protection trusts, for example. Life insurance trust could be irrevocable. Once I transfer that asset into an irrevocable trust, it's basically like transferring it to a separate entity. An irrevocable trust has to have its own tax ID. It has to file its own taxes every year. And I no longer own the property once I put it into an irrevocable trust. So I might be able to receive money over time, almost like an annuity from that trust, for example, but then it has to have a different beneficiary for it to pass on. So for example, if I created an irrevocable trust, I could take lifetime benefits from it, but upon my death, the assets would pass on to other people. I wouldn't be able to take my assets back out of an irrevocable trust during my lifetime.
There's so much to know, and it's almost scary what a like expertise you have to be in such little teeny weeny areas of life, and how like the probate and the Medicaid and the income tax and everything is also intertwined.
You're right. And then you have other issues that could be coming into play. If I were married to someone from another country, for example, I work with couples with a spouse from Canada, then you have to have a totally different trust in place because somebody from another country cannot inherit more than I believe it's right now about don't quote me on this, but it's about $150,000 that a spouse could inherit assets in the United States. So then if you were to put the assets in a special type of trust, then it could be held on behalf of a spouse that's from another country, for example. There's special needs trusts.
Oh,
There's so many different trusts that are out there and available to customize for family.
yeah, and you do the special needs trust as well.
I do components of a special needs trust, but I do leave the drafting of special needs trusts mostly to experts that have done it for most of their career. Coming from family law, I have a completely different background where my estate planning experience has been over the last 10 years. So I definitely know I have referrals in place to help me either draft the trust or refer the work directly to if it's something more complex than a standard revocable trust.
That makes sense. And is most of the work that you do for people who need so estate planning, obviously a trust comes up. What else comes up with estate planning besides a trust?
Great question. So a patient advocate designation is for disability planning. So there was a pretty famous case back in 2007 where there was a young lady from Florida who became in a persistent vegetative state. And it took 6 to 7 years for her family to go through the court process all the way to the Supreme Court because the husband wanted to honor his wife's wishes that she didn't want life support, but the parents said absolutely not, she needs to be on life support. So it became really popular after that time. In order for you to have your own wishes followed is to create a form called a patient advocate designation where you would appoint. So if I were to appoint you as my patient advocate, you would have authority to decide, is organ donation something that I would be okay with, my pain medicine, my life-sustaining treatment, whether I would want an autopsy or not. So there's certain things to think about, whether I would want feeding tubes, whether I would want oxygen, a ventilator, transfusions. These are things a lot of people don't talk about unless they're watching a medical show. So that's definitely an important part of estate planning, is to have conversations about healthcare and to let someone know what your medications are, who your doctor is, what coverage you have. So that could be a whole estate planning session just on itself, with figuring out who your patient advocate would be and all the different components that's involved. And then the next document is power of attorney that we've talked about, making sure that someone's available to manage your financials. Both of those documents are only for disability planning because they do terminate on death. A lot of people think a power of attorney continues even after death, but it actually terminates upon death. And then the next document would be the trust is available if you wanted to have assets as part of a trust to be managed. If you didn't need a trust, that's absolutely fine too, as long as you have a beneficiary in place for every asset. And then also something for your house. So the Ladybird deed is almost like a beneficiary form for your house. And then a will is a backup plan. So even if I had a trust, I still want to have a will because there might be something I didn't plan for. So for example, as the song goes, if I had won the lottery and then died the next day, I didn't have a plan in place for that money. So my family would have to go to court to say that I have a trust and to have a judge sign an order transferring the asset into my trust for it to be managed as part of the terms of my trust. And there's other documents too, whether it's assigning assets into a trust or directly to someone, because we have to resolve personal property, which can be a big one as well. And even having a HIPAA authorization to fill in the gap. So if I'm on the way to the hospital, my family's trying to figure out what happened to me, my condition. Typically, the doctors and providers can't give my family any information unless there's something in my file designating a certain person or people that they can talk with. But really, one of the biggest things about organizing with estate planning is making sure a person has a list of their assets. Constantly, I hear someone passed away, and then they're trying to figure out, was there life insurance, was there annuities, where do they bank? Because now we don't have mail coming to our house with statements. Everything's in our email, online. So just trying to figure out someone's estate. So part of it is just organizing your assets as well.
That makes sense. That was one of my biggest worries of being single, was that I didn't want anything electronic. I wanted everything in my mailbox, so people would get the mail and know what's what, because you don't have somebody else paying your bills with you.
Exactly. But now if you can get $10 off your cell phone to have it electronically, the $3 to $5 the bank would charge, most of us now have everything electronically. And then digital assets is a whole nother ball game too.
Right.
Owning currency and digital assets and websites and music and pictures. Apple just came out with a new legacy program where you could designate a person to be in charge of your Apple ID, for example. So
I like that.
yeah.
That's very, very smart. And tell me about the word durable.
Durable is a term mostly used with a power of attorney, for example. So if I could create a power of attorney that says it continues while I'm incapacitated, which is, of course, when I would typically want it. let's just say I signed over, that you were going to be attending a closing for me. I could create a limited power of attorney that says that it's only available for you to act as my agent at this one specific closing. But then, of course, it's going to terminate. I'm not going to need that form anymore. But if I really wanted to do an estate plan for emergency and disability planning, I want to create a power of attorney that's durable, meaning that once I'm incapacitated, it's still in effect. And with the statutory new law that just came out, it actually took away the word durable from the statutory form.
Okay.
So a couple of the banks said, wait, is this durable? And so we had to show them the new Michigan compiled law saying, yes, it's durable as long as it's signed in front of a notary and or two witnesses, which we typically do all the above. When I have people sign documents, I like to have two witnesses and a notary.
So you're double covered.
Double covered, exactly, so that it's durable. So a document would be durable until death.
Okay.
Great question.
Awesome. What great information. What am I not thinking to ask you about, even though I'm sure there's like a bunch more?
I think one of the most important things about a trust and assets is insurance.
Okay.
So let's just say I put my house into trust upon my death. Well, now the trust is going to own my house upon death. And a lot of people think, what's the first thing that we need to do when someone passes away? And one of the first things I mention is insurance. So now that the house is in trust, I need to make sure that the insurance company updates the insurance policy to say that my trust owns the house. So one of the things I do with estate planning is we go ahead and contact the insurance company as soon as the estate plan's done to say, once the house flows into the trust, we want to make sure the trust is covered. So we contact the homeowner's insurance and say, okay, we need to add this trust as an additional insured entity. So that way, once it flows into the trust, that we have continued coverage from the individual to the trust. There has been two cases, including one in Michigan, that within 3 days after death, someone was injured at the property, and the insurance company denied the claims because they said it was no longer owned by the person, it's now owned by the trust. And there was another case recently out of another Midwest, it was either Minnesota or Wisconsin. Even considering all the people in different states that have had, whether it's a hurricane or fire damage, if your house is in a trust and it's not insured properly, that they could deny the claim.
Oh, God. And this again might not be in your realm, but it's just bringing something up. I've had a couple friends who have had mortgages with credit unions, not Fannie Mae or Freddie Mac, and their parent had passed away. And I think they're trying to get this right, but I believe the parents deeded the home to them and their child, which I know a lot of times we don't say is a very good idea, but I believe this is what happened, and it happens a lot with people thinking they're doing a good thing. And then the parent whose mortgage was with the credit union, and then the credit union would call them and say, well, your parent has passed away and they're on the mortgage, and you have to sell the house now. You have to pay off our mortgage. Where they didn't say, well, now you own the home, you could pay the mortgage. I don't know if that really has anything to do with estate planning or what people
It
think is estate planning.
Well, there is a law in place as part of, and I believe it's a federal law, and the name is around the Saint Germain Act.
Saint Germain Act, I'm familiar with that.
So as long as it's a family member whose home is the primary residence, whether it's a spouse or a child of the decedent, they should be able to show that they qualify for the exception that says the mortgage isn't due upon death because this specific family member has the right to remain in the house and to continue making a payment on the house.
But if they didn't live in the house because they're an adult child living somewhere else, then they can call it due.
Then the house might have to be sold or refinanced into the
Bummer.
person's name. And talking about insurance, I did talk specifically about trust, but the same thing, if a child were to inherit a person's house, or even if their name was added to the house, which we come across, the first question I always say is your name on the insurance policy? Because you now co-own a house, and if someone slips and falls on the sidewalk,
You could be
whoever's name is
sued
on the
too.
title is going to be sued. And the reason we usually typically don't recommend adding a child's name to a house for a parent is making sure there's liability protection. There could be gift tax issues by adding someone during the parent's lifetime. And the third reason is because there's a part of the tax code is if you were to inherit a property upon death of a parent, for example, it would step up in basis, which means if the parent paid 300,000 for the house and now it's worth 700,000, you would have capital gains on the difference. But if you inherited the property upon death, it would step up to the fair market value on the day of death and you wouldn't have capital gains. So it's always much better to pass on
At
upon death
death. I know,
in
and a
order
lot
to
of
take
people don't
advantage.
think of that. We do so much checking with the mortgage, and I had one guy is doing a mortgage for him, and through fraud guard or whatnot, it came up that he owned another property. And he's like, I don't own any other property. Well, it says you own another property, so we got to start digging now. And he found out through doing his mortgage that his mom thought she was doing them such a favor that she owned this farm and she put him and his sister as co-owners. So if she passed away, they would automatically get the house. That was her thought process. So then as we're doing the mortgage, we find out that she has this working farm that he owns,
Mhm.
and there's people that rent out land to farm the land, and there's equipment that are on this land, and then he doesn't have any insurance on this. And and the poor mom, she thought she was doing them such a favor, but we opened such a can of worms.
It's really interesting what you can come across with estate planning and how things work out and pass down. And I had a friend that inherited the grandparents' house, and it was a long Hines Drive. And of course, there's flooding, and called the insurance company to help with the flooding, and it was still in the grandma's name, and there was no coverage. Um, so it's just interesting to find out whose name's on the deed, whose name's on the insurance. And one of the things with when you buy a house, I would say 9 out of 10 people do not receive a copy of the deed. So one
No,
of the,
you don't.
you don't.
You
And
don't. Or if you do, you don't look at it because you don't have to sign it.
exactly. And I've seen where the deed never got filed. I've seen where they put the purchaser and the seller backwards. I've seen typos. So there's
I've
all
seen
kinds of,
co-signers added as owners. That
yes,
happens all the time.
yes. So one of the things I always love to check is the register of deeds and how everything's listed, how are the names listed to make sure it's correct.
Right. And you bring up a good point about the insurance when going back to like people not refinancing when they get divorced, is they probably redo their insurance to take their ex-spouse off your insurance.
Right. Exactly. So that was one of the number one provisions I had about the house was you always have to have times and dates for everything. When is it going to be refinanced? The insurance has to be maintained. Proof of insurance has to be provided to both spouses, whoever is residing there, whoever's name is on the title, on the mortgage. And that's why I love a house trust, a single asset trust, to make sure all the provisions are followed, that the house is co-owned together until the house is free and clear of one spouse, that it's all solely in the primary person that's residing there's name, and which can take years to
Right. I
have that
really need to
happen.
go back through and try to see if I can find notes of who was supposed to refinance that didn't. And now that rates have not dropped, I bet you there's a whole bunch of loose ends that no one is paying any attention to
That's
whatsoever.
right. Until there's an emergency like a house flood. It,
Right.
fingers crossed and knock on wood, but you never know whose name, yeah, exactly, whose name is on the insurance policy if they're no longer talking, or have any legal requirement to provide that information to each other.
Right. And then here you get like a $50,000 insurance check, and they're like, well, I want half.
Mm-hmm.
I own the home. I don't care if it gets fixed.
Exactly. And then trips to court to figure it out.
Oh, goodness. You are a wealth of knowledge and way more than just estate planning, which I so appreciate.
Thank you.
Is there something that you want to add that we didn't talk about that we should mention?
Well, I think one of the things that's important about estate planning too is part of my process, making sure people are organized, is password management. Passwords and identity protection, freezing or monitoring your credit reports. There's actually 4 credit bureaus, including, so of course we know about Experian, Equifax, TransUnion. A lot of people don't know about checks, CHEX.
I don't even know about that one.
Yeah. So let's just say that someone stole my identity and goes to a bank or credit union and opens up an account in my name. The banking industry contacts checks to find out whether they should open the account in this person's name. So in order to prevent that from happening, because they might be trying to get a line of credit, for example, I need to freeze my identity with checks as well as the other 3 credit bureaus to make sure, which is become easier and easier to do. There's now apps that you can download. You click on the app and it has a slide button, freeze my account, unfreeze my account. And I strongly recommend that everyone have some type of password management in place, whether it's a password app or a secure way to manage your passwords, because that's one of the hardest things. When my mom passed away, for example, I didn't know her PIN number. Even though her cell phone was in my name, I didn't know the PIN number for the billing customer service. So
You don't have the fingerprint in the face.
yes, it took a month of going into the store, showing my ID, calling and calling and calling
Oh,
to try and shut down a cell phone in my name because I didn't know the 4-digit PIN number. So that's one of the things about estate planning, getting organized, is making sure you have a list of your assets, the beneficiary designation set up, protecting your identity, making sure your passwords are in place. So I have a whole sheet of reference material that I usually will pass on to someone if they've lost a family member or friend, just helping make sure to protect even the decedent's credit by providing a death certificate to the credit bureaus to protect the credit. Because of course you hear all kinds of stories about identity theft, including, after someone passes away. So
you're already, just like divorce, you're already in this emotional, crazy state. So you're already not thinking clear, trying to do your regular life, trying to take care of this, and
exactly.
the more organized you are, the better.
That's right. It's organizing your life.
Yeah, you are amazing. How can people
Right,
get hold of you if they want to talk to you?
Well, they can call, they can text, they can email, we can Zoom, they can go to my website and put in, there are all kinds of ways to get a hold of me. I'm just look up my name, my email, all of my information is available either on my website or by calling our office number.
Tell me your office number.
248-587-7888.
And tell me your website.
Our website is innovativelawservices.com.
Wonderful. Rebecca, you are a blessing, and I thank you very, very much for all your knowledge.
Oh, thank you so much. Same to you.
Thank you. I hope you enjoyed the podcast. I'm Carri Goldring, and if you ever have any questions regarding mortgage, feel free to give me a call or send me a text message, 248-420-4524. Hope you enjoy the rest of your day.